those who didn't follow that, what you're saying is that there are people who have been reading what is actually written in the final rule, but misinterpreting it. Could you explain how they misinterpret it? Because I've heard this term total THC. It seems ambiguous to me because as we discussed, there are many types of THC. There's Delta 8, Delta 10. So in this case, you're saying that THCA is federally legal. Where specifically does it say that in the Farm Bill and the final ruling?
Okay, yeah. So the Farm Bill is very clear. The definition of hemp, tetrahydrocannabinolic acid is an acid and a cannabinoid found in the plant. So it meets the statutory definition of hemp, which is defined by 1639O in the Code of Federal Regulations, Title VII. It's important to remember what definitions are and why they are critical to understanding legislation. So the USDA final rule is something that everybody's familiar with. You'll see it discussed a lot, and you'll see a lot of highlights, a lot of copy and pasted selections from the USDA final rule. But I'm convinced that very few individuals in this industry have actually read through all of the pages and all of the content of that final rule.
Yeah, it's like 300 pages, isn't it?
Yeah, because I did. and I found some really phenomenal excerpts that I think are critical to understanding the industry in its entirety. And there's one thing that repeatedly occurs throughout the USDA final rule, and it's the USDA repeatedly stating they do not have authority to alter the statutory definition of hemp. So people need to understand the statutory definition of hemp protects THCA because tetrahydrocannabinolic acid is an acid and a cannabinoid found in the plant cannabis sativa L. So THCA is federally protected. The USDA, in attempting to assign THCA concentration a place as part of the compliance metric for hemp in the United States, by including THCA in their regulatory compliance metric, they actually violated not only the legislative intent, but also the legislative definition of hemp, basically attempted to redefine an already established legislative definition as defined by Congress.
Do they have the authority to do that? Or
no, and that's the biggest thing, is they've been running around telling everybody, hey, if you're growing hemp in the United States, we're going to test it prior to harvest when it's in the ground to make sure that it's total THC, so it's concentration of Delta-9 THC, which the plant doesn't make, plus 87.7% of its tetrahydrocannabinolic acid concentration. If that combined value exceeds 0.3% Delta-9 THC, total THC, then that product is no longer compliant hemp. The USDA is the one that said we have authority to do this. They've been publicly announcing that, so much so that they go around to the growers and say, hey, this field is non-compliant and you got to destroy it. However, publicly but quietly throughout the USDA final rule, they repeatedly state, while we're gonna tell everybody this, we know we don't have the authority to alter the statutory definition of hemp. Our regulatory definition cannot be more strict than the current legislative definition of hemp.
Wait, hold on. So for those following so far, what you're saying is that they are asserting and telling people that they have authority to add those two values together.
Right.
But they then repeatedly say, we know we don't have the authority, but we're still going to do it.
We're going to do it until presumably somebody attempts to call us on it, I suppose. But it has very profound implications because the Farm Bill, the statutory definition of hemp that the USDA cannot alter and repeatedly states they have not altered, including in Part 990, the definitions section. If you notice, if you read all 300 pages of the Farm Bill, you will see the section where the USDA acknowledges the statutory definition of hemp and then states, in acknowledging that this is the statutory definition, that definition is going to be carried over to Part 990, which is the definition section that contains acceptable THC level and repeatedly references Delta-9 tetrahydrocannabinol not tetrahydrocannabinolic acid, because they never had the statutory authority to include that in the first place.
So they are kind of misleading unless you go and you read the document. Even if you read the document, unless you go and you chase down that reference that they reference in those paragraphs, it may appear that it is THCA plus delta 9 THC, when in reality, if you read the definition that they reference, it specifically excludes THCA.
Absolutely. The USDA knows that they don't have the authority, and it makes sense. So think about if this, instead of big dangerous cannabis, was instead, those super safe firearms. So imagine if there was a law passed regarding the production of firearms, and there was a federal definition that stated that handguns could not be considered assault rifles, that the legislative definition of assault rifles could not, it specifically precludes handguns from being considered assault rifles. If then that same piece of legislation directed the ATF to write rules and regulations about firearms in the United States, and in those rules and regulations, the ATF decided to include handguns as part of their definition for assault rifles, and then try to subsequently enforce that newly established definition, that would be unconstitutional.
And the NRA would be
right. Yeah, everybody would be up in arms, because everybody knows that a regulatory authority does not have the authority to alter a legislative definition.
So for people who don't know, the I guess regulatory is defined by the legislative.
Right.
And so legislative, they cannot overstep what the legislative authority is.
Correct. And there's this famous Supreme Court case referred to as Chevron, and it has to do with the idea that the Supreme Court ruled, pending that ruling being overturned, that absent a legislative definition, a regulatory authority can define a term to mean a certain thing because there is no legislative definition, right? So that is, if you ever hear people refer to Chevron, that is the ruling, the idea. And a lot of people are up in arms about it. They think that it's unconstitutional for a regulatory authority to write any definition.
Because it wasn't passed through the legislative process.
Congress
some group of people just arbitrarily, or not arbitrarily, but choosing for themselves.
Exactly. So that's the idea. That's why there's still legal professionals that are like, we don't like the Chevron ruling. I understand that. Okay. One way or another, I'm not going to weigh in on that, because in this instance, Chevron does not apply, because there is no absent legal definition here. I mean, the federal government,
explicit.
It was very clear about hemp is this, and included in that definition is tetrahydrocannabinolic acid. So
that's incredible. I mean, I can